Florida is an extremely litigious state. It might be the most litigious state in the country. I know South Florida, people sue people for anything and everything over the most nitpicky things. Welcome to the crazy world of South Florida real estate.
Holy crap. Okay.
The U.S. government wants to make sure it gets its share of tax revenue. However they get it, they want to make sure they get it. They don't care who they're collecting it from. But if that foreign seller moves back to Canada, once they're back to Canada, they're not going to be subject to U.S. taxes.
All right, what's up, everyone? I am here in sunny South Florida, Fort Lauderdale. I am with Vito Labalestra, team principal at Compass, Vito and Anna team, James Avello, Butler title, owner, attorney. I hope I got all this right, right?
Got it.
Good? Okay.
Good job.
Okay. We're not McDonald's workers. So today, what I want to do specifically is I want to grind you, James, on a couple different, and I took notes here because I want to make sure I get everything, all right? I want to grind you on a couple of topics. Specifically, I want to talk about the buying and selling process for a property here in South Florida by a Canadian. I guess it would be the same for any foreigner, but specifically for a Canadian. I then want to go over the typical legal structures that we see for more complicated deals. Things like LLCs, maybe an LLP, C Corp, S Corp, so that we get a good primer on what these things are and what the nuances are. And Vito, obviously you've got the local knowledge. I need you to chime in when I'm saying something completely ridiculous, if you don't mind. Why don't you introduce yourself first so people know who you are and what you do?
Sure. Thanks for having me here today. So my name is James Avello. I'm a real estate attorney. I've been an attorney down here in Florida for about 15 years. Born and raised in Florida, so my entire life and practice has been based in South Florida. I opened up Butler Title, my title company, in 2018. So in the past 6 years, we've grown rapidly throughout the Tri-County area and throughout the state. We've handled thousands of closings throughout the state of Florida, and we certainly do dozens and dozens of transactions every year for Canadian buyers and sellers. So very familiar with that process and happy to dive into the details with you.
Perfect. And Vito, You've done business with Butler Title.
We've done a lot of business with, right? James and Butler.
Okay, perfect. So let's start with the first question. I'm a Canadian and I'm buying my first property here in Florida. What do I got to look out for? I'm not expecting you to know what the process is north of the border, but what is the process over here from a legal perspective?
The first question we have to address is, if you're buying property in Florida as a Canadian, are you buying with the intent of it being a primary residence or as an investment property? And then the second question that probably needs to get addressed is, are you planning on purchasing the property for cash, or are you going to be obtaining financing through a bank or lender? If you're going to be obtaining financing, there's going to be some different underwriting requirements that the lenders are going to make you go through, given that you're a foreign national buying property in the state of Florida. That's something that needs to be addressed. If it's a cash transaction, it's relatively simple and straightforward. Of course, with financing, there's going to be all the lender requirements and the lender underwriting that's going to differ lender to lender.
Plus, it sounds like the simplest transaction would be an all-cash deal, which when I looked at the details on the Canadians buying in Florida, and like I said in a previous episode, there's about 500,000 Canadians that own property in Florida. 95% of these seem to be cash deals, or at least historically have been cash deals.
And we talked about like the data in general, Florida being a cash heavy environment, like 55% of South Florida deals are cash, right? 95 seems high. I am of the belief that they're leveraging assets
somewhere else
in Canada. They're taking a line of credit on their house or whatever it is, and then buying here in cash.
Right.
It's probably about 50%.
Right. But the idea is that they're not going through that extra layer of obtaining a U.S. mortgage or U.S. financing, which makes the closing the deal a lot simpler, I would assume, as you had mentioned. But in that simple scenario where me as a Canadian individual or myself and my spouse as a couple want to buy a process, it seems like it's a pretty straightforward, property. It seems like a straightforward process then. All cash deal, foreign national buying a property. Are there any nuances to the process, or is it really just a straightforward putting together the paperwork thing?
Definitely more simple and straightforward when purchasing cash. Of course, you get to eliminate all of the issues that come with obtaining financing. So no worries about bank underwriting approvals, appraisals of the property. So from that perspective, pretty straightforward. There's still, of course, nuances that come with respect to what type of property are you going to buy. Even if you're buying cash, if you plan to buy a property in a condominium, which is very common down here in South Florida, condominiums have their own set of rules and regulations that even cash buyers, you're going to have to adhere to the condo rules and regs. Very often, there's going to be a condo approval process that you're going to have to be approved by the condominium. You're going to have to check whether or not the condo allows for rentals if you're planning on buying that as an investment property. So there's certainly some things you'd want to check out and be aware of before you just sign a contract. Obviously, working with a realtor like Vito and his team, they can help guide you through that, answer any questions so you know what you're getting into. But in terms of the actual transaction itself, it's a pretty straightforward process. Once you identify the property you'd like to purchase, fill out the contract, sign it. And from signing that contract to closing, I would say typically we can get a cash deal closed in about a 15-day span, if not sooner. So it's straightforward in that regard.
Yeah, I have a really simple question that a lot of people ask. Might sound like a stupid question, but do I actually have to be here physically to sign this stuff, or can I just DocuSign this crap?
So not a stupid question at all. We probably get that question at our office 3 or 4 times a week. So it depends if you're a buyer or a seller. If you're buying property and it's cash, you can DocuSign the documents. If you're selling a property, documents require notarization. Now, that still doesn't mean you have to be present in Florida at my office. We can have a notary meet with you in Canada or wherever you may be, or there's something called remote online notarization, which is essentially allowing you to log in to a video conference call, essentially a Zoom call with a DocuSign, and allows you to DocuSign, remotely sign, and have your documents remotely notarized. So,
and you can be the notary for that?
My office facilitates that remote signing through a third-party authenticator.
So the idea is there's some technology and some flexibility in the process. Now, when I am buying a personal use property, let's say there's no intention ever to rent it out. There's a couple of follow-up questions I have here. You mentioned an approval process by a condo. Now, I bought multiple condos and my clients have bought hundreds of condos in Canada. I've never heard of an approval process specifically for a condo. This sounds to me like the condo board or the owners would want to do some sort of a background check on you. Am I correct?
Yes, that's right. That's essentially what it is. So not every condo is going to have different rules and regulations, but very commonly condos are going to require a prospective purchaser, a buyer, to submit an application. Usually there's a small fee associated with that of $100 or so. Submit the application. The association is going to want a background check done on you, perhaps a credit check, criminal history. They want to make sure they're not letting a criminal or a convicted felon into the into the neighborhood, so to speak. So they're going to run a background check. They're going to get all of the information on you as a purchaser. And subsequent to that, they're going to issue an approval. And then once you get that certificate of approval, then you can proceed with closing, assuming all the other requirements of the contract are met.
Yeah, so you can't close without the certificate of approval.
So if you're an ex-drug dealer, you got to make sure that
oh, they'll deny you.
Yeah, I'm dead serious. Like if you have like a DUI or something, like if you have a previous conviction, then this could be an issue.
We had a deal where the buyer didn't disclose information. They put the wrong address that didn't match their driver's license, and then they found a battery charge.
No.
And they denied him at the last minute. It sucked because he was a good kid.
But he was denied by the condo board or the association.
It was an arrest, not a conviction. And it was something that was ultimately thrown out, but it came up in a background check because he didn't disclose it on the questionnaire. Have you ever been arrested?
Okay.
They declined him and he couldn't close on the property. He got his escrow money back.
Yeah, this is an interesting point I've never heard of. Whether this exists in Canada or not, I'm unaware. I've never heard of this. But it does make a lot of sense that an HOA, like a homeowners association perhaps, might even do this, not just a condo board, would do something like this because they're like, hey, listen, if you're going to be living in our community, we don't want a bunch of degenerates moving in.
Right. Well,
right.
And James, how often do you see that a buyer gets declined by a condo? Because you do a lot of closings, right? I only do the ones that I'm visible to us, right?
Sure. I would say that it's not very common where we get a denial. I think the two main things that the condo boards and the HOAs are going to look at, probably similar background checks, similar credit checks. The main things they're looking at are violent history, of course, of arrest records, and financial strength. Financial strength is certainly something they want, specifically in the condos, but perhaps the HOAs as well, because with condos, one of the things that is of concern is that the buyer will buy into the building, and if they don't have sufficient financial strength, if there's an assessment that comes down the line that needs to be imposed, that buyer won't be able to cover their respective share of that cost, and that could lead to an issue. So most common reason, at least that I see for denials, and they're not very common, would be financial related. Either a subpar credit score or just poor financial.
So you have minimum credit scores that are disclosed up front. So these are things that us as realtors, we have the conversation with a buyer, because if they have a bad credit score, we might be able to get them a loan, right? But we can't get them through the HOA. And especially even in these like 55 and ups, they want to, because you have fixed income.
Yeah, they want to see a pension or whatever.
Pension, they want to see that there's reserves, that they can cover the fees. And I'm sure they run into a lot of challenges with that, with inflation. And
so this makes a lot of sense. I never thought of this, but yeah, some sort of financial due diligence by the HOA or by the condo board. Is it all HOA? Like, so am I condo board, HOA? Is this like an interchangeable word?
Yeah, I guess.
All right, let's get technical here. Why don't you educate me on that?
I think for our purposes today, you could use them interchangeably. There are some technical differences.
Okay.
An HOA stands for a homeowners association. Okay. Usually that's going to be single family home communities. Condominiums or condo associations are going to be condos, which are a specific legal structure, a shared structure with common areas, everybody owning an undivided share of a common element. So a little bit different in terms of the structure and the legalities, but for our purposes, it's the same thing with a governing board that requires approval of the buyer.
Excellent.
Yeah. So like you guys don't have a lot of HOAs in Ontario or in where we grew up, right?
No, it's
not very uncommon. You see gated communities, like they're few and far between, and they're in these like ultra wealthy environment communities, right? But you may or may not have heard the term condo commando, right?
No.
This is like the guy on the board who wants to control everything, and like you got to watch out, because that's the guy who's going to start denying people,
right?
And sometimes for the wrong reason, right? And
just upon a power
I had to
trip.
call James and say, "Hey, this guy was denied. Can we get him out of this?" There was another incident we had where the condo board owner was fighting with the owner, and this is funny because it was the place that he sold, right? Gave a bad reference to the place that he was buying, so it was condo board member to condo board member, and the new place he was trying to buy denied him.
Oof.
Because he got in a fist fight with the owner of the other place. It was bad. It was like the poor old man.
Welcome to the crazy world of South Florida real estate.
Holy crap. Okay. So, I mean, listen, I guess the overall point is, there's going to be some form of a due diligence if you are going to be living in some sort of a community that has some sort of collective agreements amongst themselves, which is a very common structure here in South Florida, right? It's not something that we're really used to. It's like I bought a couple condos over the last few years, and you buy a condo and that's it. They get a clearance certificate and done. Bob's your uncle. It's super easy, right? But
they can't deny you.
I mean, I suppose they could. I suppose they could deny you, right? But I've never heard of it, right? Okay, so that's a good safeguard. Now, is there any real major difference between an individual or a couple buying, like in terms of the ownership structure, tenants in common, joint with rights of survivorship? What do you got for me there? Like, is it pretty straightforward, or is it a completely different ballgame when a married couple or common law spouses buy a property?
Sure. So I guess the first point is, of course, if you're an individual buyer, you're the only person who needs to get approved. It's your financials. Obviously, if there's a cash deal, there's no approval of that. But if it's a cash individual buyer, it's just you. It's your credit. It's your financials. It's your background check. You're the only person who's going to be considered and interviewed and approved. You add another person to the mix. Now you have another person that needs to get approved. That they could potentially, if they have poor credit, that could potentially be a negative. That could be a drawback. They're still going to be a co-owner. They're going to be presumably on that contract. They're going to be on title to the property. They're going to need to get approved. They're going to need to submit an application. So you don't have two people in the mix that things could go wrong for that person. Even if one person has great credit, the other person may not. So something to be aware of there. With respect to how you own the property, so there's ways that you hold title if there's more than one person. Two common ways in Florida for individuals, there's going to be joint tenants with right of survivorship. Pretty much just means if you and another person buy a property with right of survivorship, one of you passes away, the surviving person gets 100% ownership. The other structure is called tenants in common. So you and the other person own it as tenants in common. One of you passes away. The other surviving person does not automatically get 100% ownership. Your 50% interest would pass to your heirs. That's the other way to do it. If you're a married couple, the default would be survivorship, right of survivorship.
Right, automatically. Even if the other spouse isn't even on title, they have to sign off on the sale because it's a spousal state, right? How does that work?
Well, you're talking about on a sale. So I'm referencing on a
just on a buy. Yeah.
Right. So on a purchase too, I guess
On
if
a
you buy it and you have a spouse, you could buy it alone, but the spouse automatically inherits it or owns it.
Well,
owns
joint with rights to
50% of it.
survivorship, by definition,
But if you don't put them on
in any
title.
common law jurisdiction, is going to be you die, whomever it is that is joint automatically gets it.
Whether they're on, but what if they're not on the title, right? So I go out and I buy a condo or a house, and I just go sign the papers. I buy it cash, and it doesn't know, right?
So then it would go to your estate, I'm assuming, and your will would dictate where the property goes.
That's right. And then there's obviously nuances that come into play. This gets tricky and lawsuits happen. And we have to perhaps go down the probate road depending on if the property is going to be homestead or not, because in Florida, homestead gives rights to surviving spouses. But if you're alone on the deed, sometimes there's ambiguity of whether or not you properly claimed homestead. I'm actually dealing with that right now on a closed transaction from last year. But there's some complexities when you don't have both people on that title. So the general rule of thumb is if you're married, you want to put both people on that title just to avoid any issues down the road. The surviving spouse for homestead is protected, but don't leave that up to the court. Don't leave that up to interpretation.
It's expensive. Yeah,
it's expensive. It's timely. So if it's not going to be if it's not going to be an investment property, which we can get into that in a second, investment property should always be held in the name of an LLC. And we can go into that. I'll pass it back to you to ask any questions. That definitely for primary residences have to be, of course, in an individual name. You can't have a primary residence in an LLC because a corporation or a company can't have a homestead.
How about a trust?
Trust is a little bit of a different animal. So you can have a homestead in the name of a trust. However, a trust does not offer any liability protection.
Correct. Okay.
And that would be a living trust of some sort.
That's right.
That in the event of you passing helps the probate process or passing that asset down through
with multiple beneficiaries.
That's right. So a trust is an asset protection vehicle. So a trust is not a liability protection tool. It's an estate planning tool. It's an asset protection tool. So when you have a trust, that's a way for you to avoid probate. So for instance, I have a revocable living trust. I own my home in my trust. If I pass away, I don't actually own my property. My trust owns my property. Whoever I've designated as my beneficiaries in my trust would ultimately become the beneficiaries of the home. So that's a way to avoid the probate court. But if you passed away without a trust and you didn't have your property titled in a trust, even if you have a will, and I'd like to point this out, I get this question a lot. If you have a will and you leave your property to your son, your daughter, you still have to go through the probate court because the court has to validate that will, make sure that it's proper, there's no challenges to it, and then the court will determine that, okay, it is a proper, valid will and property can be devised to that beneficiary. But if you're not going to own it in an LLC because it's not an investment property, certainly a trust is a smart way to avoid the inevitable death that we're all going to face at one point.
So I wanted to get into the sale of a property, but I think that naturally this conversation is going over to various different structures. So I do want to start getting into the different structures. Now, one of the common structures in the United States that we don't use in Canada is an LLC. Okay. And my assumption here with my minimal knowledge of US tax is that LLCs are great because essentially a flow-through entity. It gives you the protection, the legal protection or the liability protection of a corporation without the potential for double taxation because you flow out the losses and gains and whatnot. So we do have, and similar to you guys, we do utilize LPs or limited partnerships to achieve that sort of thing in Canada, but we do not use an LLC. And one of the problems from a cross-border taxation perspective is that an LLC is, from a US tax perspective, is not seen as a taxable entity, unless of course you make an election to make it a taxable entity. But on the Canadian side, when you read the Canadian tax legislation and when you look at the guidance from Canada's side, an LLC is considered a corporation. Now, when a Canadian has a property here in Florida and rents it out, generates some form of income, you must file a tax return here in the United States because you've generated some sort of income in the United States that's taxable here. The Canada-US tax treaty, like the very many tax treaties that the United States has with other countries, we want to avoid double taxation. So generally speaking, the Canadian will get credit dollar for dollar for the most part, and I'm really simplifying this. They will get credit dollar for any US tax paid on their Canadian tax return. The LLC creates a complication because it's super useful here in the state of Florida to set up an LLC, but because it's considered a corporation in Canada, any taxes paid in the United States, we don't get credit for, leading to a double taxation situation. So we often look to other structures, sometimes LLC to C Corp to Canadian Corp, which allows a flow through, all right? Or we may use, I think you guys use limited liability partnerships as well. And that gives us some protection, at least up to the contribution amount, which would be the equity that you put in. I don't want to go down this rabbit hole because this is more something for a cross-border tax specialist whom I will be interviewing in greater detail. But I do want to go into the LLC structure and what it is, because it is still useful in some cases for Canadians, but Canadians don't really know what an LLC is, right? They're very familiar with the corporate structure. They are somewhat familiar with a partnership structure. LLC is, you might as well be speaking Greek or Chinese. I don't know what the hell you're talking about. Why don't you explain, just from a basic Law 101 standpoint, to somebody who just has never heard of this structure, what it is and what it is meant to achieve?
LLC, which stands for a limited liability company, is it's a legal entity. It's a structure that allows the individual to be separate from the legal entity to allow for protection, liability protection in the event of a lawsuit. So it's a creature of state statute. So each state has rules, statutes that govern their individual LLCs and how they're structured.
So there's no federal legislation for LLCs. It's state by state.
It's a state creature. It's an entity that's created based on state statute. Okay. Now, like you mentioned, LLCs are pass-through entities from a tax perspective. You can elect to be treated as an S corp, or you can not file an election with the IRS, and then it's treated by default as a partnership, and the money flows from the entity through the individuals. Like you mentioned, it's a pass-through entity. Certainly, it's the most common form of entity for buyers and holders of real estate in Florida. I imagine in other states too, but at least for our purposes, by far the most common vehicle. And the reason that it's the most common vehicle for property owners of investment property down here is that it allows that ability to separate the individual from any liability that they may incur. Perhaps you buy a rental property, you have a tenant in there, the tenant slips and falls and breaks their neck. Yep. Well, if you owned it in your individual name, you could be subject to a lawsuit individually, and all your personal assets could be subject to a judgment. If you own it in an LLC and that LLC has no other assets other than the property, that's the extent of the liability. So, there's some nuances to that with if you're a single member or a multi-member, and can the court what's called pierce the corporate veil. That's beyond the scope of this discussion. But for all intents and purposes, owning a rental or an investment property in an LLC is by far the most common. It gives you liability protection. It offers a lot of flexibility with a lot of the corporate other entity types for example, a C corporation, there's a lot of corporate formalities that have to be adhered to, meetings and minutes. LLCs kind of give you the benefit of the liability protection with the flexibility of not having a lot of the legal rigidity that comes with some of the other entity structures.
Right. So maybe like a less involved minute book, less involved declarations.
That's right.
Right.
Easier administratively. It's much more inexpensive to maintain. It's, I believe, $135 a year to file your annual report with the state. You can get an LLC filed with the state online within, it takes me 10, 15 minutes to file one. Usually within 48 or 72 hours, it's active and up and running. So, if you buy a property and you realize, I want to put it in an LLC, as long as your contract allows you to assign it, you could do that a week before closing, and usually that's not a problem. So it's certainly the most common for all those reasons: flexibility, cost, ease of administration, and then of course the liability protection.
Okay. So let's pivot over to now a C corp, which is a very common thing that we utilize when a Canadian is expanding a business into the United States. So I'm going to just drift a little bit off from pure real estate right now because I have you here and I want the free advice. So a C corp, what I know a C corp as, it's very similar to the corporations we use in Canada in the sense that it's a closed entity, meaning that it is taxable in and of itself and then makes a dividend distribution of its retained earnings. Can you explain what a C corp is and how it differs specifically from an LLC?
Sure. So I'm not a corporate attorney, so I don't want to butcher this too much. Take this with a grain of salt. Yeah. But the C corporation, it's a different entity structure. There's obviously different tax treatment than an LLC. As I previously mentioned, there's going to be some more rigid record keeping and administrative requirements. That probably the biggest difference that most people point to as anti-C corp structure is there is the issue of the double taxation. So income that comes into the C corporation is subject to tax at the corporate level, but then all the dividend or profit that then gets passed through to the individual shareholders is then also subject to taxation. So you are getting hit with that double taxation, which is why a lot of people are anti, C corp, especially for real estate, because some of the other factors with C corporations that allow, why would the largest corporations in the world be structured as C corps? They have to do that for different, banking and fundraising rules. So, big corporations are C corps for various reasons when it comes to raising money, being listed on federal stock exchanges, for that matter. Again, that's kind of beyond the scope of this conversation.
But for the smaller operation, it's probably not the most advisable.
I work with, plenty of local, investors, developers, contractors, and I would say all of them, if not all of them, 99% of them, all have their businesses structured as an LLC, often with an S corp election. And then, of course, there might be multiple layers of LLCs where a parent LLC will own subsidiaries. And that's probably the most common structure to separate maybe an operating business from maybe a holding company.
Yeah, no, I had a US, when I used to do US tax, I had a US client that had LLCs in every single state, and it was just a mess.
With our Canadian investors, we see them use an LP, right?
And that's the final structure
LP
I wanted
then
to.
has a general partner, right?
Yeah,
and a limited partner,
right?
The limited partner takes
the investor.
Is the investor. The general partner is another LLC.
That's right.
And that LLC takes the liability for the partnership. And then beneath that, they layer it with additional LLCs that each individually own an asset.
Okay.
Right.
So,
and that's pretty common with an LP structure.
Right. So the final structure that I did want to talk about is a partnership, a limited partnership. And once again, I don't want to get into like the huge nuances of structuring a cross-border deal, because I am going to interview a specialist on that, like on structuring something cross-border, because it's it's outside of my scope of practice.
And there's so many different variables.
And there's so many nuances.
Because where's the money coming from? Is it coming from a corp?
Yeah.
What's that investor's specific situation? Then you got to get their Canadian accountant on the line and talk to the cross-border guy and kind of figure it out. And
but from a basic standpoint, though, a limited partnership, or sometimes I see a limited liability partnership, which we have LLPs, but those are generally limited to like law firms, accounting firms,
Yeah.
professional
Same
firms
over here.
right? So a limited partnership, why don't you explain the basics of a limited partnership, how it works, how it limits liability?
Sure. So with a limited partnership, again, another different type of an entity structure, you're going to have a general partner and a limited partner. So two different types of partners in that partnership. The general partner is going to be effectively, think of it as the operating partner, the partner who's going to do the heavy lifting, do the work. They're going to be, the one managing the operation. That partner often, and again, the typical lawyer answer, it depends with, how it's structured, who the partners are, how complex their organizational tree is. But the general partner, the managing partner, if you want to think of it in that context, the person kind of doing the heavy lifting, organizing all the activities. The limited partners are really passive investors, for lack of a better word. So if somebody wanted to bring in some investors who just want to be strictly capital partners, not really be involved and really just get a return on the investment, they would be deemed a limited partner, to really simplify it. And the person who's boots on the ground, kind of running the show, whether it's the developer, the general contractor, the group that's putting the project together, they would be deemed the general partner.
Now, legally, I know north of the border, and I'm not a lawyer, but legally, my understanding is that the general partner is the only one that can call the shots in an LP structure, and the limited partners are truly limited to their capital contributions, right? Is this the same sort of thing here in Florida? The limited partners don't call the shots unless they are also part of the general partner.
I would say that's, again, it depends. The typical lawyer answer. It depends on what your limited partnership agreement is. So the LPA or your limited partnership agreement, which you should always have, regardless of if you're best friends for life or if you're working with somebody for the 30th deal, have an LPA, have a partnership agreement that outlines all the rules, responsibilities, and rights of both partners. And like you mentioned, pretty much that goes with the territory. The general partner is going to call the shots. And they're going to say, listen, this is what we're doing. I'm going to have the rights and responsibilities to manage this. And the limited partner is really just going to be along for the ride. Now, of course, you could carve out, restrictions with respect to that to kind of protect your interests. But for the most part, on a general level, that's right.
Okay, perfect. So let's put a pin on that. Super good explanations. Give us the 101 on like the basic business structures. What I want to do now is I want to get a really good understanding of two different topics. I'm sure we have time for that. The first would be the selling process, right? And, the selling process for a foreign national, because that's a lot different. Okay. And I also wanted to talk about the litigation process. Like it's the United States is more litigious than Canada in general, right? And I think it's something that surprises Canadians who come to the United States and do business here or buy rental properties or whatnot, or even just have property, period. I want to sort of prime the Canadians to understand the legal environment here. So if we can go first on the sale of a property, because it is not a straightforward process. And sometimes people's money, like Canadians' money, will just be trapped in trust at a lawyer's office for a very long time because of the red tape involved, right? So typical person sells a property here in South Florida. They're Canadian. Is it different if it's a rental property or a personal use property? Does it matter?
Great questions, and I'm glad you brought it up. I'm literally dealing with that exact situation as we speak. So we'll start at a high level. Typical sale of a property owned by a Canadian. It doesn't matter if it's residential. It doesn't matter if it's commercial. It doesn't matter if it's an investment. If you're selling a property as a Canadian, you are going to be subject to FIRPTA. FIRPTA is a tax withholding that essentially the U.S. says you're not going to pay any capital gains tax on your sale because you don't pay taxes in the U.S. So in order for the U.S. to get some tax revenue, we're going to hold back, generally speaking, 15% of the sale price of that property. There are some exemptions to that rule. If you're selling a property that's under $300,000 and the buyer is using it for at least 50% of the time for the next 2 years after closing as a primary residence, we can get an exemption from that FIRPTA withholding.
And that's interesting because it's the buyer is using it for the next 2 years as their primary residence, right?
At least half the time. It's a very complex, nuanced rule. But the short and sweet answer is you don't control, of course, what that buyer is going to be using the property for. So it's very good to have that conversation up front with your agent. Your agent can talk to the buyer's agent, get an understanding of if your property is going to be subject to this withholding. And that's completely dependent upon whether the buyer, who you have no control over, how they're going to use your property at closing. So if they're buying it in an LLC, by default, FIRPTA is going to apply, because if the buyer is an LLC, it can't be a primary residence. So that's a red flag right there to note. If an LLC comes across your way as a buyer on a contract, you need to be aware FIRPTA is going to kick in.
Interesting. We actually dealt with this, I think, earlier this year.
Probably a few times.
Yeah, but one recently where the seller and the buyer were both Canadian, and the seller wanted them to sign something saying that it was going to be their primary residence, so they didn't have to be subject to the FIRPTA, and it was a $300,000 transaction, so it was right at that limit. Remember the condo here on the beach? I forget the other agent's name. But what I never quite understood, and help me out because I've always wanted to ask you or somebody this, is like, why does it really matter what the buyer's using it for? Is it because they still have to pay the taxes, right? Is it? I understood this, or I heard that the IRS can come back to the buyer and ask for the tax revenue if the seller doesn't pay it.
So that's right.
Like, so why does it really matter with the new person coming in if they're going to live in it or sell it or whatever?
Think of it like this.
The seller's the one that's got to pay.
Yeah. But
right?
think of it like this. So we have similar rules in Canada, right? So it is the person remaining in Canada that is going to ultimately be responsible for the tax, because Canada cannot enforce a tax law outside of its own jurisdictional borders. So
right.
To me, it makes sense.
Why would I, as a buyer, want to take any risk?
Well, you have no choice. That's the law.
No, you do, because the buyer has to voluntarily sign this addendum.
Oh, I see what you're saying.
That says, I'm living in this, and you're good with not doing the 10% withholding.
Think of it this way.
Why would I ever? Like, I don't know the seller. I don't know their accountant.
Right. Well,
I don't know if they're going to
think about it this way.
$30,000 to the government. Right?
The U.S. government wants to make sure it gets its share of tax revenue. However they get it, they want to make sure they get it. They don't care who they're collecting it from. But if that foreign seller moves back to Canada, once they're back to Canada, they're not going to be subject to U.S. taxes. So the government says, okay, buyer, you are now in Florida. You are now the owner of this property. We're going to come after you, and you're deemed the withholding agent is the term they use. You're going to be subject to this tax if we find out through an audit or other means
that guy never paid,
that tax was in fact due, and we can't now go after the seller. You're on the hook.
Yeah. So again, right? Why would you ever, as a buyer acquiring a property from a non-resident, even give them any opportunity to be off the hook?
Well, that only applies in the limited exemption circumstances where it's under 300,000 and you truly are going to live there. If you're a Canadian planning on moving down here and you're going to live in that property 50% of the time or more for the next 2 years, and you truly are, there's nothing wrong with signing it, just like anything else. If you're going to truly do that, you can sign it. The reason I get what you're saying.
But there is, maybe I'm missing something, right? But I'm a Canadian. I sell you a property. You're whatever, you're American. You're going to live in it as your primary. I don't pay the taxes because you signed this piece of paper because it's an exemption rule, right? IRS is going to come to you.
There's no taxes due.
What if there's taxes due?
There's no taxes due. There's an exemption. That's what I'm saying.
So under 300 grand.
Under 300 grand, and the buyer signs that document, there's no tax due.
There's no taxes due.
Period.
Ah.
That's why it's not a risk.
Okay. Got it. So I always understood that there was still taxes due.
No, it's a carve out.
Okay, cool.
It's a carve out.
I learned something.
Perfect. Okay.
That's great.
I guess the main point that people have to understand is you sell a property in Florida, you're not American, FIRPTA could come into play, and the people that are going to be interested in this are going to be buying properties over $300,000, right? So FIRPTA is going to come into play. There is going to be a withholding tax. You probably are going to have to file some form of pay some form of capital gains tax here in the United States, and then that will release the remainder of whatever is sitting in the lawyer's trust account,
That's
Or
right.
whatever's sitting in escrow.
And I'll piggyback on that. And that's right. So you sell a property, the sale price is more than $300,000.
Right.
FIRPTA is applying. There's no exemptions at that point. It's just a matter of if it's 10 or 15%. And there's some nuances to, again, how the buyer is going to use it. And if it's under $1 million, we can get a reduction down to 10%. If buyer signs the primary residence affidavit and it's under $1 million, we can drop the 15% down to 10. That said, over 300,000 Canadian sellers should be expecting a 10 to 15% tax based on the sale price. Now, that said, that doesn't mean that that's the tax that they actually owe. That's just the preliminary figure that we have to use to calculate it before we actually dive into the financials. In order to understand what the true tax liability is for that seller, they'll often hire a CPA, or they'll hire a firm, perhaps FIRPTA Solutions, or one of these firms that specifically focuses on FIRPTA transactions. They'll dive into the basis of the property. They'll understand your costs, your expenses, any capital improvements you've put back into it to get a true understanding of, I bought it for this amount, I put this amount of capital improvements into it, I sold it for this amount. This is actually my tax exposure. It might be quite less than the 15% that we as attorneys have to hold back in trust. Now, that requires, of course, filing the appropriate paperwork to the IRS, showing them the paper trail of why you only owe a certain amount of money. And then once the IRS receives that paperwork, they'll usually make a determination. Of course, they're not the quickest, but 6 months to 12 months, depending on how quickly your particular auditor is, they'll give you a ruling and say, okay, we agree with your calculation, or we've recalculated it to be this, and they'll send back a letter saying, okay, perhaps I held back in trust $100,000. If the taxes owed are 50, I remit the 50 back to the seller and I pay the 50 to the IRS. Now, again, without getting into too much specifics, the closing agents, the attorneys, we have to remit that FIRPTA withholding to the IRS within 20 days of closing the transaction. We are allowed to not mail it and hold it in our trust account as long as you file what's called a withholding certificate, essentially these forms to the IRS, letting the IRS know you're aware, you're going to be submitting your documentation as to why your taxes owed are not the flat 15%. I still have to withhold the flat 15, but I can hold it in trust, and getting it back from me is going to be a lot more simple than trying to get it back from the IRS.
Right. So you're going to want to sign that paper to get that paperwork
Yeah, and
done.
it also depends on sometimes how close you are to the tax cycle and when taxes are due.
That's right.
Because we've had a seller of a Canadian property that said, you know what, I'm not going to go through the whole process of filing a withholding certificate because taxes are due in like 2 months, and I'm just going to file it
Anyways,
and I'm going to get my return.
Right.
And the person was one of the parties was American.
Right. But I guess the overall point that I wanted to drill in here, I mean, nobody's going to be able to figure out how to do this crap themselves. It's too complicated. The idea, though, that I want the Canadian investor to understand is it's not a straightforward process. Like when you sell a property in Florida and you are a Canadian, there is a withholding tax. Anything above $300,000, there's going to be a withholding tax. And it's not a straightforward process to simply get that money released. You're going to have to file U.S. tax returns, calculate your capital gain properly, get an assessment by the IRS or an approval of the calculation by the IRS. And once that is done, if there is anything left over, then the money will be released to you.
That's a great summary. Okay. And like you said, it's not simple and straightforward. There's a lot of very, very stringent deadlines that have to be adhered to. There's a lot of specific paperwork that has to be, properly filled out, timely filled out. So whenever you're selling property, probably even more so than buying, but both sides of the coin. Whenever you're buying property in a foreign country, think about it. Would you go buy property in a foreign country without a local counsel or a local attorney?
Of course not.
Guiding you and explaining all the nuances? I mean, the standard as-is contract that we sign, that Vito fills out for his buyers and sellers, that we see 99% of our contracts in Florida come into our office. It's an as-is contract. It's 13 pages. It's it's pretty detailed, but it's a boilerplate form that outlines the general scope of the transaction. And somebody from another country who's not used to maybe as litigious as Florida is, to segue into that, Florida is an extremely litigious state. We might be the most litigious state in the country. I know South Florida people sue people for anything and everything over the most nitpicky things. And, escrow disputes over the buyer's deposit happen all the time, whether they're justified or not. Just because a buyer wants to back out of a deal, maybe they feel like they should be able to. Maybe they feel like it's justified. Maybe they feel the seller lied, misrepresented something, committed a fraud. That all may be true. But at the end of the day, until a ruling is determined, that escrow deposit has to sit in my trust account until somebody decides through a court process, a mediation, whatever it may be, that this is how we're going to release those funds. So to kind of get into that, the litigation side of things, Florida is extremely litigious, and you're often dealing with people who are not reasonable. And if you don't have proper counsel, both on a real estate side and an attorney's side, you can find yourself, in a sticky situation. And if you're a buyer, your deposit, and often six-figure deposits, tied up for months and months on end, and you're not getting any interest on that money. It's held in my trust, and you can't use it for any other purposes until you resolve that dispute. So it's definitely something to make sure, if you're going to buy or going to sell, have an attorney review the contract, jump on an initial call to have an understanding of what are your rights, what are your responsibilities, what are your obligations. Always happy to do that. Of course, I do that every day, talking to buyers and sellers about, should we add this clause in the additional terms? Should you be aware of this? Explaining FIRPTA. So it's definitely always better to have an initial consult with an attorney before you sign, because once a seller signs a contract, this is an important point. Once a seller signs a contract, there's no backing out. A buyer has a 10, often 10, it's negotiable, but anywhere from a 5 to a 15-day inspection period, which is essentially a cancellation period. That term is, of course, negotiable. You can waive that, which is not recommended. But if you're buying a property as a buyer, you do have in the boilerplate contract a right to inspect, which gives you an ability to cancel if you're not satisfied with the condition of the property. Once the seller signs, they're obligated to sell the property at that contract price. They're, of course, obligated to deliver free and clear and marketable title, but they can't back out. They can't have a change of heart. Once a seller signs, they're committed to sell, or they're going to be liable for, potentially liable for.
So injunctions are common, like to have a judge enforce a contract, then it would be straightforward, or is it still? I know you're not a barrister, right? Like you're not a litigator, are you?
I'm not a litigator, but there's two remedies in the contract. And again, maybe this is getting too deep into the weeds, but if you have a contract dispute regarding the purchase and sale contract for the property, there's really two avenues you can explore as a buyer or as a seller. Frankly, the contract outlines the remedies. But if you're a buyer and your seller decides, I'm not selling this property to you, I had a change of heart, I don't want to sell it, I don't like you, whatever their reasoning may be, if they're not signing on the dotted line at closing, you really have two options as a buyer. You can take your deposit and go home, or you can sue for specific performance. You could also sue for monetary damages. Usually buyers don't have that many costs that have racked up. Sometimes they'll have an appraisal cost and some inspection costs.
Really
you throw that in or whatever.
You could throw that in. Usually that's a relatively small amount of money relative to the scope of the transaction, $1,000 or two. There are times where you've incurred moving costs, you've hired movers, you've moved all your furniture. Now you have storage costs to store all your furniture.
Sold your house and you might
have to rent a property.
What about it? Market value has increased.
Right.
Maybe you have a long closing period and something happened in the economy and now that house is worth 20% more.
Got it.
And they don't want to sell it.
Yeah. And that's an issue that we ran into probably more so back a few years ago when the market was rapidly increasing month over month. A seller would sign a contract, call it in May, and then fast forward to July when it's the closing day. That property's worth $100,000, $200,000, $300,000 more. That seller says, "I'm not going to close. I'm going to resell it for $300,000 more." The buyer, of course, is saying, "No, you're not. I'm going to sue you for what's called specific performance," which is their right to enforce the contract. They have to bring that lawsuit to the court. The court has to, of course, hear the case, and the judge would then have to rule that we are enforcing the terms of this contract. The seller's obligated to sell at the contract price.
Right, and is that look, court here has got to be something similar to court in Canada. It's a lengthy, expensive process.
That's right. It's not fast. It's expensive. You're going to have to hire a litigator. You're going to have to go through the motions, literally file motions, go through the typical litigation process. And at least down here where we are in South Florida and Miami-Dade and Broward and Palm Beach counties, tons of population, tons of lawsuits. So you're going to be put into the queue, and you're not getting that resolved in a month or two. That's going to take time. And oftentimes buyers, when they speak to a litigator, they realize unless it's a very unique property where they really want to make sure they get it and they have the wherewithal to afford to fight the case through the system, they just decide, I'm going to take my deposit and go home. Or oftentimes I've seen a couple of times in the last few years where a buyer will say to a seller, cut me a check for X amount of money. I had a seller cut a check to a buyer for $50,000, and they said, give me 50 grand and I'll sign a release of contract and we'll go our separate ways. So there's ways to settle with anything. And oftentimes it's not worth pursuing a formal legal action.
Right.
Yeah. Like I've seen buyers that were in the right, clean contract, and the seller being unreasonable and misinterpreting a term of the contract and just saying, nope. And the deposit was so small, it was like 20 grand.
Yeah.
And it was like, by the time you go through the process, the buyer just was like, okay, let's just split it. I'll take 10, you take 10, we walk away. And it's a shame, right? When you see something like that.
And everybody just wasted their time and their energy and their efforts.
Right.
And, fast forward and nobody walks away happy.
Okay.
And that's a pretty common.
So I think from a summary standpoint, like you're buying a property, it's not until that title has transferred over to you, don't really count your chickens before they hatch, right? Because there are going to be
or your commissions.
Or your commissions. Or
definitely don't count your commissions.
Definitely don't count your commissions.
Until they're wired by me.
Right. Okay, so purchases, sales, we got the basic business structure, a little bit on the litigation side. I kind of wanted to finish off, and I apologize if this is not your area of expertise, but you seem to know what you're talking about here. But what are the other sort of litigation or legal issues that someone could run into, specifically if they're buying rental properties? Is there, maybe not from an operational standpoint, but setting up the rental property, getting the financing in play? And if you could give some examples, if you have any, of things that could go wrong in all these processes from a legal perspective for a foreign national.
Sure. So there's probably two ways to look at that. There's what could happen before the closing occurs. So from signing that contract until the closing date, anything can go wrong in a typical closing process, just like whether or not it's an investment or a rental. And then after closing, you acquire this rental. In theory, there's an existing tenant in there, and then everything that could go wrong liability-wise. So before you close, you're going to have a contract presented to the seller. The seller signs it. You should know when you're writing that contract to present to the seller whether or not that's a tenant-occupied property. That's something that the seller would let you know. You would be buying it based on the rental income and make your decision. There's a provision in the contract that says this property is occupied and subject to a lease. You as the buyer have to honor that lease for the remainder of the lease term. So you should always get a copy of that lease, review that, make sure you're comfortable with the terms of that lease, because you're going to inherit that as the new owner, as the new landlord. So if you don't like the terms of that, whether it's the amount of money, whether it's some of the liability provisions, know that up front. Know that during your inspection period, because if you see that lease and you don't like how that's written, you shouldn't buy that property, or you should see if you can get an amendment to that lease by the seller, because he's the one who has liability or the ability to contract with the tenant. So you'll know going into that transaction, there's a tenant subject to this lease. I'm ultimately inheriting that lease. I have to honor it. And then, of course, when that lease comes up for renewal, you can decide if you want to renew it under new terms. But you are bound as the new owner under the remaining terms of that existing lease. So, of course, interviewing the tenant to know who's going to be living in this home that you now own is probably a good idea if you have the ability to do that. Even speaking with them on the phone to get a sense of who they may be, that's a good idea. Of course, getting insurance policies in place. Of course, that needs to be done if you're getting a loan. That's a mandatory factor. If you're buying cash, technically you don't need to buy property insurance, although that would be very crazy, especially down here with the weather and the hurricanes that we get. But plenty of people roll the dice, especially maybe in the winter, and say, I'll get insurance in a few months and save a buck. Not recommended, of course, but So there's that pre-closing. And once you sign on the dotted line, title transfers to you as the new owner. You're now a landlord. You're now a property manager. You're now somebody who's got some extra liability. You should certainly own that property in an LLC so that tenant doesn't slip and fall and break their neck and try to sue you personally. If you have it in an LLC, like we spoke about, you're protected in that regard. The company's the one liable, not you. What else is there? I guess there's always the typical risk of, the tenant defaulting. If they don't pay that rent, they become a squatter. I think we were talking offline about that a little bit. What happens if that tenant just decides, no, I lost my job. I'm falling on some hard times. I can't afford to pay.
You missed it. Then we got to call Julian and security and.
Well, then we got to call the property manager.
They had the sheriff there. They shot the guy. It was,
well, let's try to avoid doing that if possible.
He lived only in the leg, but
I mean, with any investment, a rental property is an investment. With any investment, there's risk, and the risk for real estate investing is there's default risk, and that's the default to the tenant paying that monthly rent on time. So that's a very common scenario, and if you do have to ultimately evict that tenant, just like the litigation process for enforcing the contract, you have to, file a formal eviction, hire same thing, an attorney, a litigator who will file the proper paperwork to formally evict the tenant. And again, not necessarily the quickest process. And I'm not a litigator, but there are legal means to go through that process. And it's certainly not the fastest, and it's certainly not pleasant, but it happens all the time. So the more you know up front about the structure of the lease and the quality of the tenant, the more peace of mind you'll have going into the closing.
Perfect. So I have one final question. I just want to make sure I got everything for you. How common is it outside of default or evicting a tenant? How common is it? And this obviously I'm asking you anecdotally, right? We're not pulling up any stats, but how common is it to get some sort of legal troubles or litigation from just the tenant, maybe like some sort of a fire or injury or is this a common thing here in Florida?
I have no stats behind that, but I would imagine so. I mean, I can just tell you off the top of my head, one of my best friends, my whole life, he's on his third tenant in his townhouse in a couple of years. The first tenant, broke his sliding glass door and certainly cost more than the security deposit to replace. Got in a fight with somebody in the property, punched a hole through the drywall, had to bring out a handyman to replace the drywall, stopped paying the rent. Of course, then he had to hire an attorney, like I spoke about, to get the tenant evicted. And of course, there's cost that gets incurred with all that. So it could be anything from weather-related stuff to fires, to floods, to violence in the property, to tenants not paying. All these things ultimately come down to, lost income because you have to pay handyman to fix it. You have to release it. You have vacancy. You have monthly rent because if you have a mortgage, that mortgage is still due whether or not that tenant's paying. So, I have no supporting stats, but I would say again, it comes down to the particular tenant, but I would say it's fairly common. I wouldn't want to spook a buyer to make it sound like don't buy rental property.
Right.
I have rental property myself, and I have very good tenants. I'm very fortunate, but if anything, it's luck of the draw.
Right. But in terms of the tenant suing the homeowner for some sort of negligence, or is that a common occurrence?
Similarly, I think that really depends on the condition of the property and the responsiveness of the landlord. The landlord has certain obligations under the lease. They have to keep the property habitable. It depends on what the lease says specifically. But of course, the landlord can't let, the power go out and the air conditioning break and a roof leak to go on for, 3 weeks without addressing it. So landlords have a duty of good faith, just like a tenant has to operate in good faith to keep the property habitable. And if you quickly address that and you remedy that, usually people are appreciative of a landlord responding. They understand things happen, things break, and landlords, as long as they quickly address these things, usually that can be resolved. But with anything, if a landlord is neglecting the property and not, fixing the things that they're liable to fix, a tenant might say, well, I'm not going to pay you. And now you get into that type of dispute where it's who's now responsible for what. And some of that is a matter of interpretation, but most of that is pretty spelled out pretty clearly in the typical standard Florida lease that we use.
Perfect. Okay. Well, you know what? You've covered everything that I wanted to cover. Obviously the basics. I don't want to get too in the weeds and technical here, but that was awesome. Do you have anything else you want to add?
No, I think this was awesome. Hopefully it was informative. It's always great catching up with Vito.
Yeah.
Thank you.
Yep.
Catching up with you. I would just like to say, I think I mentioned it before, if any of your clients, any Canadians out there looking to buy and invest in Florida, always happy to have an initial conversation to let them know that I'm happy to review the contract, explain the process, go into a little bit more depth with any of their specific circumstances or questions. And likewise, if you're selling property, certainly have an attorney review the contract, explain FIRPTA, explain what your tax liability may be before you sign that contract. Because once that seller signs the contract, there's no backing out.
Perfect. And we're going to put all your contact details, socials, and everything in the description. So hope you get some business out of this, man.
I appreciate it.